today we're going to be talking about what to do when someone dies without a will, and really the importance of having a will and knowing what happens with your assets upon your passing. And again, also, I think there was a subtopic sort of preventing will contests or how to avoid them. And I think you'll see why it's so important to have a will and to designate, beneficiaries of a will. There was just an article in the Wall Street Journal in the first section this morning about making sure there are beneficiary designations on accounts. So for retirement accounts, IRAs, 401ks, 403bs, always make sure you do have beneficiaries named on those accounts, as well as life insurance, even bank accounts to have named beneficiaries. So the overall topic is what happens when someone dies without a will. And we're just talking about when someone dies, and for the legal consequences, we're not going to be talking, theoretical, religious, philosophical, just sort of what happens, what a will is, what happens to assets upon your passing. Please feel free to ask questions along the way. When I do screen share, I can't always see a message in the chat. So just feel free to unmute and ask a question. It's not a problem.
I'll monitor the chat as well, Sarah.
Oh, I appreciate that. Thank you. So today we're going to talk about the importance, what is a last will and testament, the importance of it, key provisions to have in a will, and then what happens when you pass with a will and what a probate proceeding is, and what happens when you pass without a will, what an administration proceeding is. And those proceedings are all brought in the surrogate's court. Here, if you pass in Westchester County, a resident of Westchester County, the proceeding is brought in the Westchester County Surrogate's Court. Okay, sorry, my mouse is moving very, very quickly today. So why is it important to have a will? And then again, we'll talk about what happens when you don't have a will, but I think it helps emphasize the importance of a will. Have a will because that way you can name who the beneficiaries are who to inherit it from your estate. So for example, I have a will and it says, I, Sarah Myers, leave everything to my spouse, Kenny, if not my spouse, to my kids, and my kids in trust till they turn, I think it's either 25 or 30. So I designate who I want to be the beneficiaries of my will. I then also say, I'm appointing an executor. I believe my husband is the executor to marshal to handle the estate upon my passing. And if my husband should predecease, I think it's probably my brother who's the alternate executor. So I'm choosing who my beneficiaries are, who's going to inherit upon my passing. And also I'm choosing who should administer the estate, be the executor. And in terms of choosing my beneficiaries, I'm also choosing that if my husband should predecease me, my children should inherit, but they should be certain ages when they receive those funds. So I can direct, and with a will, I can assess and address all of those issues. I can make a specific bequest of my engagement ring to one of the kids. I can make a specific bequest of the piano to another kid. But again, I have control as to who is going to inherit, who are going to be the beneficiaries, and who's going to be in control of the estate upon my passing. If I pass without a will, we look to the New York State, what's called the EPTL, Estate Powers Trust Law, the EPTL, I rarely ever say it, the full name of it, as to the family tree of when you die without a will, who are called what are called distributees. Who receives the monies, the assets that are in your name. And if a person passes with a spouse and no children, the spouse receives everything. If the person dies with a spouse and children, the spouse gets the first $50,000 plus 50%, and the kids get the other 50%. So we use me as the example. In my will, my husband gets everything if I predecease him, and if not him, the kids. And again, in trust for the kids to certain ages. If I didn't have a will, 50% or your 50,000 plus 50% would go to my husband. And then if my kids were all over 18, they'd each receive 1/3 of that other 50%. I can't control, I don't have a trust created for them. There are no other criteria. You have no control. You have to follow what the New York State statute does say. And I think this is a really good chart in terms of what happens for the assets upon your passing when you don't have a will and there was what's called an estate administration. So what does that mean? Stepping back for a second, I pass away and there's a bank account in the name of Sarah Myers. And anyone who's been on any of these programs knows in my lifetime, if I don't have capacity, if I'm unable to handle my financial affairs, if I have a power of attorney, a document that says I'm appointing someone to make financial decisions for me if I'm unable to do so, the agent under the power of attorney can handle my financial affairs. Upon my passing, that power of attorney dies with me. So if there's a bank account in my name alone, the agent under the power of attorney upon my death can no longer access that account. That account is frozen until an administrator is appointed of my estate if I don't have a will. So then a person, my spouse or children or remote descendants would have to petition the court and say, hey, court, Sarah Myers passed. She left no will. We believe there are assets in her name. I'm the person who should be in charge of the estate. So again, like a will where you have the executor and I get to choose who my executor is. When I don't have a will, I don't get to choose the executor. With New York State follows, again, the rules of intestacy to see who should be appointed the administrator, which is the same as the executor, but when you die without a will. So here, if you die without a will and you have no spouse and children, your children receive everything. If a child should predecease you and has children, and you have 3 kids, for example, that predeceased child's children would get 1/3. You would receive that predeceased child's 1/3. If you have a spouse and no kids, the spouse receives everything. If you have the spouse and kids, as we talked about earlier, the spouse has the first 50% and then 50-50 the spouse and the kids. If you pass with no spouse or kids, then New York State looks to see if your parents are still alive. If parents are still alive, the parents inherit. If your parents are also predeceased, New York State looks to see if there are any siblings who are still alive, if your siblings are still alive. And if your siblings are predeceased, if your siblings had children. So again, it can be rather complicated if a person dies with no spouse, no children, no parents, no siblings, to even find those more remote descendants. But again, with following the New York State statute, we do know the line of what are called distributees. So when we die without a will, as we said, there's an asset in my name alone. There has to be an estate administration. A person says, for example, if I didn't have a will, my husband would petition the court and say, hi, I'm Sarah's husband. She passed. Here's her original death certificate. She passed with a spouse and children. I'm going to want to be the administrator, and then the court can appoint me, my spouse, the administrator. Once all bills are paid, again, they have to follow the rules of intestacy to distribute, as we talked about before, the first $50,000 to the spouse, then 50-50 spouse and children. So again, I, as the decedent, have no control over my estate and who gets what and in what manner, because again, I don't have a will, so we follow the statute. Sorry. Issues can come about. So let's say I pass and I don't have a will and my spouse predeceased and I have 3 kids and the 3 kids don't get along. They can fight as to who would be the administrator of the estate. So yet again, another good reason to have a will is because then it's your choice. You have control over who would be the executor, and the kids don't fight in an administration proceeding as to who the court should appoint, who should be the administrator of the estate. And there is an order of priority for granting what are called those letters of administration. The statute first looks to the surviving spouse. If there's no surviving spouse, the kids. If no kids, grandkids. Then they look up the chain in terms of parents, then siblings or siblings' children. If there are no siblings if there's no spouse, kids, parents, siblings, and the closest surviving are the siblings' children, they can petition the court, but more often than not, the court will appoint what's called the public administrator to administer the estate. So again, there comes a point in time where it gets more complicated when you pass without a will and no immediate family in terms of administering the estate. And yet another reason why it's important to have a will and to be able to control how your estate is handled. Okay, what happens what assets are those that pass through the will or through intestacy? Any asset that's not in my name sorry, let me start that one again. What doesn't pass through a will or an estate administration? Anything titled to a trust. So if I have the Sarah Myers Revocable Trust or the Sarah Myers Irrevocable Trust and their beneficiaries named in the trust, that trust, those assets are not part of what are called the probate or administration estate, because my trust should have beneficiaries named. So if I have the Sarah Myers Revocable or Irrevocable Trust, I name my spouse as the beneficiary, if not my spouse, my kids. That falls outside the probate or administration process, because again, that's an asset that has named beneficiaries and it passes to them through the trust. If I have a life insurance policy with a named beneficiary, that too passes to the named beneficiary. If I'm the beneficiary of a life insurance policy, the individual has passed. I notify the life insurance company. I provide an original death certificate. I fill out whatever forms are required. They can pay the death benefit to me. What's something to be very mindful of with a life insurance policy? I have a life insurance policy. My husband's the named beneficiary. My husband predeceases me. I never had secondary beneficiaries on that, named on the life insurance policy. The proceeds then are payable to my estate because there were no secondary beneficiaries named. So it's very important for life insurance policies, retirement accounts, we'll get to in a minute, to not just have a primary beneficiary, but have secondary beneficiaries as well, in case your primary beneficiary should predecease you, should pass before you. So IRAs, 401ks, 403bs, qualified annuities, non-qualified annuities, all retirement accounts, those again should all have named beneficiaries as well as alternate. Because many times if there is a couple situation, one spouse will name the other as the beneficiary, the other spouse will name the other spouse as the beneficiary, but more likely than not, one spouse will predecease the other. So it's always very important to have secondary beneficiaries. There's just a question here. I have a will through an attorney. I don't recall our car being mentioned. What happens there? I listed beneficiaries for all financial accounts. So most people don't list, unless it's a, old car that has value. Most people don't have specific bequests of cars in their wills. If you look at the DMV website, if you pass and you have a spouse, one car can go pass to that spouse, and there are forms on the New York State DMV website in order for a car in the name of the decedent to be transferred, the ownership, the registration, to the surviving spouse. If there is not a surviving spouse or there are multiple cars, once a will is admitted to probate or there's an estate administration, then the administrator or executor of the estate then either sells the car or, as the administrator executor, transfers ownership to a beneficiary named under the will or in the estate. I hope that answered that individual's question. If not, feel free to add a follow-up into the chat. If there's a bank account and it's in my name joint with my husband, if I die first, that account goes solely to my husband's name. It passes by what's called operation of law. That's not an asset that passes through the estate. Same for a bank account. If I have it in trust for or payable on death to my kids, upon my passing, they go to the bank. They say, here's mom's death certificate, and the bank divides the account 3 ways. If I own my house joint with my husband, if I should die first, that house again reverts the ownership solely of my husband's name. We do not have to probate the will or do an administration there, because if it's titled joint with right of survivorship or joint spouses, that passes upon passing of the first spouse to the second spouse. So it is important to know how your assets are titled. So that was a long way of explaining then, or getting to the point of what happens, what assets fall under your will or an estate administration. Anything not listed here being, if I have a bank account in my name alone, it's not joint with somebody, it's not titled to a trust, it has no name beneficiaries. Upon my passing, nobody has the ability, legal authority to access that account. That account falls under my estate and will pass through my will or through the estate administration. Okay, so what should a will have and who should do a will? Anyone over the age of 18 who is of, quote, sound mind and body can execute a will. That's it. Right? I'm over 18. My kids, if anyone's over 18, they have capacity, they have a sound mind, they can execute a will. What does the will contain? It can contain a specific bequest. I give each of my kids $100,000. It could be I give my oldest daughter my mom's engagement ring, or it could just say I give all my tangible personal property to my spouse, my kids, my brother, my sister, to charity, whomever I choose. Then it could just say what's called the tangible personal property, which is your non-monetary things, your clothing, your furniture, your jewelry, things of that nature, your artwork. You could say make specific bequests of certain pieces of art to individuals, or you could just say so and so or these individuals should have all of the tangible personal property. And then comes what's called the residuary estate, where I leave everything else, basically all my cash, my bank accounts, to these individuals, or to whomever I choose. I then can appoint my executor or executors. I can appoint trustees, right? If I'm leaving something to a minor or disabled individual in trust, we need to have a trustee. And then we can state whether or not the trustees, executors are to be bonded in order to basically make sure the assets of the estate are protected. But the most important part, and again, perfect segue here, is once a person is over the age of 18, right, they can inherit outright. So I could say to my 3 kids, and period, not leaving any provisos or any trusts. If they are under 18 at the time, everything stays at their share stays in a trust until they get to be, the age of majority, the age of 18. However, I can say a lot of people don't want kids or family members, someone inheriting outright if at 18, they might want to wait till 25, 30, 35. So you can create a trust for minors or younger, young adults or younger beneficiaries. We could do also, in terms of estate planning, doing some Medicaid planning, doing, lifetime trusts, Medicaid trusts, marital trust in terms of estate planning and estate tax planning. But if you don't have a will, you don't have control over these kind of provisions and terms. So again, the reason why it's so important to have a will is so you get to dictate to whom you want your assets to go in any proportions, pro rata percentages, and who should be in control of handling your estate. A will has to be in New York State, pursuant to New York State. A will must be in writing. It must be signed by the testator, the person who is doing the will, and it must be signed by the testator in the presence of 2 witnesses, and they all must be in the room at the same time. And there's always, like our office, most offices that I know of do what's called a will signing ceremony. Someone would say, person who did my will, Sarah, is this your will? Is anyone forcing you to sign it? Does it give away your assets the way you wish them to be given away? Can we be the witnesses to make sure that this is what the person wants? We have everybody initial, not just sign the will, but initial each page. So a page can't be slipped out or put in to change, what the will says. And then the will has to be sealed. It has to be affixed and as stapled, or sometimes there's a ribbon that goes through it. Because again, if the will is unstapled, there is a question once it's stapled of whether or not anybody made any changes to that will or took a piece of paper, took one page out and put another page in. So what are some common mistakes to avoid?
Can I ask a question?
Of course.
You know how they're always on TV shows, often they say somebody's amended their will, and as long as it's written on a piece of paper and signed, it counts. Is that not true? In New York, it's more difficult. So in New York, let's say I did my will a couple of years ago and I want to make a slight change. My firm, we find it cleaner and neater to do a new will, but other attorneys will do something called a codicil, like an amendment, an addendum to the will. My handwriting after my will has been done and I handwrite, I don't want anything going to my oldest daughter. I want everything going to my second daughter. There's a presumption that it's what's called undue execution. Because again, it's harder to prove that I didn't do that under duress. I didn't do that with the appropriate witnesses. It makes it more difficult to prove, I guess, for lack of a better word, authenticity. So if you do want to update your will or make a slight change in a codicil, I would always recommend going to an attorney to do that and not just do something handwriting. Those are handwritten wills are known as holographic wills, and those for the most part are not accepted in New York State.
Thank you.
You're welcome. Also, if you are a beneficiary of a will, you should not be the witness to the will, right? Because there's then a presumption of undue influence that someone is, that beneficiary is forcing you to sign it is, the witness as well, which cannot be done either. You have to be what's called disinterested. Also make sure in a will, like some wills have, and I'm just working on a probate petition now, where there are about 15 specific bequests in the will of multiple, different bank accounts and whatnot, different pieces of property. The will was actually done in the 1970s, and there's no catch-all of, for any other assets, my residuary should go to X, Y, or Z person. So there should always be a catch-all residuary phrase. Can I be unmuted so I can ask a question? You should be able to unmute yourself right? You should be able to unmute yourself.
I just allowed it.
Oh, okay, thank you. Is there a question or the person unmuted and asked? Okay. Also, make sure when you're giving descriptions, when you're meeting with your attorney to do a will, that it's very clear. Don't just say my house in, New Rochelle, New York, that I leave to my kids. Give a specific address. Don't just say my account at Merrill Lynch. Give a specific address. Be as very clear as possible, or don't just say the ring in the jewelry box. Be very clear of which the ring is, because the clearer you are, we want to make sure that what you want, your direction, is being met.
I had a question.
Yeah.
What's the difference between Donald? I'm upstairs. What's the difference between having, like, this is my second marriage, and we got married 20 years ago and then created a will at that time, and now we're going to redo them. How to protect yourself if one of the children of the marriages, this mixed marriage, is estranged from us? How do we protect ourselves that she doesn't feel the right to go after any of this money if we choose not to give her any?
Okay, so, and I think that's an excellent question. So I'm going to answer a question you didn't ask or make a statement, which is why it's so important to have a will, because if you didn't have a will, even if a child is estranged, right, we know the child gets, is part of that 50% that the children then split. So let's say I have 3 kids, one of whom I'm estranged from, who I haven't seen, in 20 years, who's not part of the family anymore. So I can leave my estate, right? It's my choice. I have my will. I say everything to my 2 daughters, and I list them. And then there's then a statement in the will. I'm specifically not leaving anything to child X, Y, and Z for reasons known to her.
You have to put that sentence in there.
Right, so got that so far. But then again, just so to be very clear, when a person dies and their will is being admitted to probate, not just the people named in the will are noticed that the will is being admitted to probate. When a will is being admitted to probate, you're required to notice what are called distributees, your spouse and your closest blood relatives. Even if, let's say I have the 3 daughters and one doesn't receive anything under the will, when my will is being admitted to probate, that daughter has to be noticed that the will is being admitted to probate. She has the opportunity in any, to object and say, I object to the will being admitted to probate. I believe my mom was under, undue influence, didn't have capacity at the time she signed the will, or was forced to sign the will, but then she would have to prove undue influence or lack of capacity. And if she's been estranged for 10, 15, 20 years, and there are a couple of witnesses who would testify to that effect, right? It would, it'd be very difficult to challenge. The best way to avoid an issue in terms of a challenge, especially if you're not leaving something to one of the kids, is to create trusts and put assets in the trusts, because that way that child who's estranged or that individual who's estranged is not noticed that of a trust administration. So if there is concern about a child contesting a will, even if you're of sound mind, have no medical issues, have no issues vis-a-vis dementia, I'd recommend creating a trust and having the assets titled to the trust, and upon passing being distributed to the beneficiaries named in a trust. Did that help?
In the
Did that
trust, is this
answer your question?
revocable or irrevocable?
Either one. You could have a revocable trust, because upon
And
your
also,
death, it
what if
becomes
you don't know where the
irrevocable.
person's living?
I'm sorry?
What if you don't know where the person is?
So if they're not a beneficiary named in a trust, it doesn't matter, right? Because they don't have to be noticed of a trust administration. If there is a will and there is a probate, the court will require the person to do due diligence to find that individual. And the court may require locating, using a PI, an investigator, to find that person as well. So again, if the whereabouts of the estranged child are unknown, yet another reason to do a trust, so we don't have to worry about the probate of this will and locating the estranged child. Did that
Okay, what about
answer?
if you just left less money to that child and more to the other three?
You can do that. You could do all of those different things, but again, you still have to find the child.
Right. You do have to know where they are.
Correct. It's hard to distribute, right? Yes, it's hard to distribute assets and give notice to someone when you don't know where they are.
Because we want to have an irrevocable trust with our house in it. Are you going to go over that at all?
We weren't going to, but we can in a couple of minutes. We could talk about that goes part of Medicaid planning. And putting assets into a Medicaid asset protection trust, also known as an irrevocable trust. Let's just go through some of the things that should be in a will, and then we can touch on Medicaid trusts as well. Does that work
Okay.
for everybody?
Yes.
Yes.
Also, a big mistake, and this is always important, to name an ultimate beneficiary. God forbid, if the whole family's on vacation, grandparents, children, grandchildren, and the like, and God forbid something happens, it's good to name an ultimate beneficiary of who should inherit. God forbid something happens to everybody at the same time. So it's always alternate trustees, alternate executors should be named as well. So what is the probate? Let's demystify what happens. So if someone passes away, they have a will, or they don't have a will.
A seminar on.
I'm assuming that person should just mute. That what happens? What's the administration and probate process? What happens is this: the original will with the original death certificate and a probate petition gets filed with the court. And we always see on TV or in the movies, grandpa dies and the lawyer is sitting at the head of the table, and you have all the family around the table for a will reading. It doesn't really happen. There's no requirement in New York State to read the will to all of the beneficiaries. So the people listed in the will, the beneficiaries of the will as well, are given notice that the will is being admitted to probate, and the closest blood relatives, the distributees, are noticed as well and have to sign something called a waiver and consent to the will being admitted to probate. Then when all the paperwork is filed with the court, it takes the court probably just about 6 weeks to what's called admit the will to probate and issue letters testamentary. And that's the evidence that the executor has that they're now formally the executor, and they can act as as the fiduciary of the estate and marshal the assets of the estate. They pay the bills of the estate and all the expenses, and then after 7 months can distribute assets to the estate beneficiaries, again, after all debts are paid and all taxes are paid. The same with the estate administration, except there's no will to probate. There's what's called an administration petition filed saying there is no will, but this person died. Here's the original death certificate. Here's the family tree of the distributees. And again, then the court will issue letters of administration for someone to administer the estate the same way the executor would administer the estate. Marshal the assets, pay all the bills, make sure all taxes are filed, properties sold or deeded, to the beneficiaries, and then just, distribute the estate assets to close the estate. Who can petition to be, for probate? It's the person named as the executor under the will. If the executor has predeceased, is unable to act, then you have the alternate executor. If there should always be an alternate executor named. And if there's no alternate executor, then a distributee can petition to be the administrator of the estate. And we talked about, how filing the probate petition. And as I said earlier, do not unstaple an original will, because then there's a presumption that that it might have been revoked or something untoward may have happened with the will. And again, we talked about notice and who is going to be noticed. And let's go to let's segue here as our time is starting to run. So how to avoid a will contest and how to avoid probate. Well, it's not always, if someone is disinherited, they can always challenge the trust and say that was done under undue influence. However, it's just much harder logistically to do. But to avoid probate in general, or avoid having to do an estate administration, it's important to use a trust, either irrevocable or revocable, and have named beneficiaries on all accounts, or joint accounts with right of survivorship. And therefore you've created what's called a non-probate estate. So if I predecease my husband and we have a house that's in joint name, he's the beneficiary named on all my retirement accounts, and all our bank accounts are titled jointly. When our brokerage account is joint, or either he's the named beneficiary, I've avoided probate because all the assets pass to beneficiaries named or through a trust. So I wanted to answer the question about the irrevocable trust that was asked. Most irrevocable trusts are also known as Medicaid Asset Protection Trust, whereby if I've created this trust and deeded my house or retitled assets to this trust, after 5 years, the assets in that Medicaid Asset Protection Trust are fully protected from Medicaid and the cost of long-term care. Most people, that's why most people use the Medicaid Irrevocable Trust. But the woman who asked the question, if you want to unmute, and we can make sure we clarify what you were looking at, your question. Okay, so I guess she logged off. But if you are still here, feel free to unmute and ask the question. But I think that begs the question is, what's the difference between a revocable trust and an irrevocable trust? So a revocable trust is used to basically avoid probate and for ease of management and privacy. The files in the surrogate's court are not sealed. So I can go over the surrogate's court and say, so-and-so passed away last year. I'd like to see the estate file. And they're actually accessible online as well. So any of the probate petition that's filed or the administration petition, those are not sealed by the court, and those are accessible, can be accessed by the public. So a lot of people like to use trusts because those are not filed with the court. And again, you have the privacy of nobody, they're not filed, they're not on record anywhere. Also, as we talked about earlier, upon passing, no one can access the account that's in my name, right? It's sort of frozen pending the will being admitted to probate or letters of administration, letters testamentary being issued. With the trust, if the assets are in the trust, I'm the trustee, and then someone else, my husband or my kid is named as the alternate trustee. Upon my passing, that person can immediately start acting. There isn't that gap, there isn't that period of time between passing and being able to act, because there's a successor trustee, an alternate trustee named in the trust.
And you said a will can't be opened, but how do you if you want to change your will, you need to know what's in there now. So how do you access that?
Well, it can't be unstapled. I mean, if it's an envelope, you can open the envelope. You can't unstaple it.
Where is it stapled usually?
A will should be stapled at the top, or
okay, so you just can't, you can read it, but you just can't unstaple it.
Of course, yes, do not unstaple an original will.
Okay.
Okay, like again, once you do a new will, a will will revoke all prior wills, but don't unstaple your original will. not to copy it, not to send it to the kids. Do not unstaple an original will.
Can you get a copy of it though?
Of course. So what we do in our office is before we staple the will, like right after the testator, the person who did the will signs it, and the two witnesses sign it as well as the witnesses, and the witnesses' signatures are notarized. We right away scan it, so we have and copy it, and then we seal it. We do it all very quickly. But yes, once it should be, a copy can be made or should be made before, or just you do one copy it one page at a time once it's already stapled.
Don't you need more than one copy so that your executor has a copy?
That they can, or we tell our clients, just if it's okay, keep everything in a note, let your executor know where your important documents are. Or if you want, yes, you can have a scan, email, give a copy to the executor, scan a copy over to the executor, or make a copy. So once there's a copy, you can unseal a copy, just don't unseal,
The original.
don't unstaple an original will. Does anyone else have a question? So the difference between, let's just to answer this the question from before, so we were explaining what a revocable trust is. Most people use an irrevocable trust or a Medicaid asset protection trust when they're doing Medicaid planning, because as we said before, the assets in the Medicaid trust after 5 years are fully protected for Medicaid from the cost of long-term care. Once the asset, though, is in the Medicaid trust, the person who's created the trust and transferred the assets to the trust no longer has control of that asset. The person cannot be what's called the grantor and the trustee. So a revocable trust, the assets are still yours, you still maintain control of. Once the assets are in an irrevocable Medicaid asset protection trust, those assets you don't have control of. They are no longer, they're not owned by you, they're technically owned by the trust. And you can still live in the house. Let's say you deed your house to the trust, you still have the right to reside there and keep all the property tax exemptions, STAR, VA, and whatnot. But again, for Medicaid purposes, that asset is protected after 5 years. If I take a brokerage account and retitle it to the Medicaid trust, I'm not entitled to the cash from that brokerage account anymore. I can put a provision in that a trustee can take funds out for another trustee, but I can't access those funds directly. So sometimes people get nervous about putting assets into a Medicaid trust, but again, once they're in the trust after 5 years, the big benefit is those are fully protected from the cost of long-term care. And deeding a house into the trust or your co-op, or transferring the shares of the co-op or deeding the condo, it doesn't affect the day-to-day of living in the property. And again, it gets the benefit of protecting it for Medicaid purposes. Any other questions, comments, or concerns?
Yes, the person you put in charge of the trust, should that person be your power of attorney? Should that person be your executor? And what's the difference between those two terms?
Okay, so you can choose whomever you want to be the trustee of your trust. So a trustee is the fiduciary, the person who's responsible for administering the trust. An executor is the person named under the will to be responsible for administering your estate. So for your will, it's an executor. For the trustee, it's a trust. The agent under the power of attorney does not have authority to act and administer in your lifetime the trust. That's handled by the trustee. And upon your passing, the agent under the power of attorney no longer has legal authority to act. The power of attorney dies with you, and you have to wait for if there are bank accounts in your name alone, for the executor to be appointed to access those funds. You can have one person in all 3 roles, wearing all 3 hats. You can have different people where one person is the agent under the power of attorney, one person is a trustee, one person is an executor. It can be the same. It does not have to be. That's a very personal choice, and it's not the same for any 2 people.
It's a little overwhelming with the terminology and who does what's
So let's break it down for a second. So a power of attorney, that's a document that says if you, God forbid, in your lifetime, you're unable to handle your financial affairs, you're appointing somebody to do it.
So I become incapacitated, there's a bank account in my name, there's a house in my name. I can't, handle those financial affairs. The agent under the power of attorney does. Is that clear?
Yes. So
Okay,
that's the only time they're in effect is if I can't do things myself
correct. And I'm alive.
and I'm alive.
The executor is the person named in the will to handle my estate when I pass. So the executor is the one who hires the lawyer to do the probate petition. And once the letters of testamentary are issued by the court, brings those to the banks, is responsible for administering the estate. That makes sense?
Yes, I'm little by little seeking in.
Good. And then there's the trustee. So if I have the Sarah Myers Revocable Trust or the Sarah Myers Irrevocable Trust, and I have a brokerage account and my house title to that trust, the trustee is the person who has the authority to deal with the brokerage account, to sell the house, to pay the bills on the house. But they're all what are called fiduciaries. They all have a financial relationship with me, either by being the agent under the power of attorney, being the executor of my will, or being the trustee of my trust. They're just called different things depending on what the document is.
Now, can the trustee sell your house that's in the trust?
Yes, but if you're living there, they can't sell it unless you're okay with that. So if you're deceased and your house is in the trust, the trustee can sell the property
But if
unless
you
there's
are
a
living there-
specific bequest to another person. If you're alive and your house is in the trust and you are living there, the trustee can't, sell the house from you. Sell the house, while you're living there. You have what's called the right to reside.
So for 5 years, that's the way the look back is in New York, correct?
That's actually federal. The 5-year look back for nursing home Medicaid is part of the federal guidelines. That's for all 50 states. There's a 5-year look back for nursing home Medicaid. That went into effect back in 2005 under something called the Deficit Reduction Act. Does anybody else have any questions?
The cost of doing all this, is it charged, is the person charged by the hour? Are they charged by the item? If I want a trust, if I want a will, does each thing have a separate cost to it?
So I can only speak for my firm. When we do estate planning, be it a will and, a trust, the powers of attorney, we charge a flat fee depending on all the documents that we would be doing. Most firms do what's called estate administration or the trust administration or doing the probate. Most people I know do that hourly. But, the fees depend on, the work to be done.
Okay.
Anybody else have any questions? So I just want to thank again the Yonkers NORC and the Yonkers Public Library System for inviting me to come spend the hour with you doing some, adult education, legal education. I hope everyone can have, some takeaway from our presentation this afternoon. And thank you for joining us.
Thank you.
Sarah, we actually have another question from someone in the private chat. They said something about having like a bank account, and then in the will, do they need to designate like my bank account at such and such bank, like a savings or a checking, and then how they want to split that up, like a percentage wise?
Okay, so I believe I understand the answer. I will try to answer it. So I have a bank account at Bank A. I have one of my kids as the beneficiaries named on that account. So that account won't pass through the will because it has a named beneficiary. If I have an account at Bank A with no named beneficiary, if there's there's two options. I can, and I want my daughter to get that account, I can have a specific bequest in my will of saying the account at Bank A should be specifically go to my oldest daughter. Or if there's no specific bequest of that account is what's called goes to what's called the residuary estate, like the bucket of all the funds that'll then be divided up among the beneficiaries of the estate.
Thank you. Yeah, no, that makes sense.
Okay.
Is that the same for your checking account?
It's any account. If the checking account is joint and you pass and the joint owner is still alive, it passes by what's called operation of law to the joint owner. If that account has a named beneficiary upon your death, it passes outside the will to the named beneficiary. If there's no named beneficiary, no joint owner, it passes through the will. And again, either through the residuary, or I can have a specific bequest. My checking account at such bank goes to such and such person. Any other questions? So I hope you all enjoyed the presentation.